Hi, welcome to Generation Rent's Renters' Rights Awareness Week session on students and how the Renters' Rights Act will be affecting students. It's one of the more complicated parts of the Act. Lots of different types of accommodation that students live in, and we have two very special guests here to help take us through those changes. We've got Nicholas Coomber from the University of London Advice Service. And we have Amira Campbell, President of the National Union of Students. Thanks very much for joining us. I should introduce myself. My name is Dan Wilson-Craw. I'm Deputy Chief Executive at Generation Rent. We have been campaigning for for much of what's in the Renters' Rights Act and a few things that didn't make it in the final version. But we're very excited about the introduction of the Act. So really keen to make sure that everyone knows what their new rights are, and can start using them and make sure that they can navigate the new rental market we now live in. We'll have we'll hear from our speakers in a moment, and then after that we'll have a Q&A where we'll answer questions from the audience. So without any further ado, I'll hand over to Nick, who will take us through the changes.
Thanks, Dan. Just bear with me while I just share my screen. 1 second. Okay, hopefully you can see that. Cool. All right. So yeah, my name's Nick. I'm the manager of the private housing advice team at the University of London Housing Services. I'm just going to very, very quickly say what it is we do and who we are, just in case you are a student at one of the universities that subscribes to us. So we offer housing advice to 25 different universities across London. So some of these are University of London kind of universities, say like UCL, King's, etc. But also we have other universities that subscribe into our service. So students whose institution does subscribe to us can get free housing advice from us. Anything from like some quick advice to a contract check to full on like kind of help with like a court case or something, potentially if you have like legal issues with your landlord. We also have a property platform and we run training for student housing advisors, hall managers, and we also have like student events like a big housing fair and flatmate finders, that kind of thing. So do go on our website, housing.london.ac.uk, and have a look if you are eligible to use our service. Okay, so what we're going to talk about today. So I'm going to talk a bit about the different types of student accommodation that exist and how they've been affected by the Renters' Rights Act. So the legal situation kind of yesterday and then today, basically, just to kind of help people understand the differences between how things were and how things are going to be now. And just kind of important things to note about kind of each type of accommodation or kind of type of legal situation. So just to kind of go over the basics, so the Renters' Rights Act is going to impact kind of existing tenancies in many cases. So anything that you've potentially signed for this academic year could be affected, and I'll kind of explain which ones are affected in a sec. The changes are going to affect kind of most tenants in England. So a lot of people are going to be impacted by this, but not everything is going to be impacted. It really does depend on who you're renting from and what type of accommodation. So different types of student accommodation I'm going to be talking about, I've kind of separated into these categories because this is kind of broadly how things are kind of affected. So there's privately rented flats and houses. And when I'm talking about that, I mean, if you're renting like a whole house or flat in a group of you all on one agreement, or if you're renting a room on your own agreement, but you don't live with your landlord. So you're in like a kind of property where everyone has their own contract for their room, the landlord lives somewhere else. So that all falls into that first category. And then also kind of student halls that are operated by private companies. So in the sector, you often find people who call these PBSAs. That's basically purpose-built student accommodation, sometimes called private halls. I'll probably call them a mix of those two things, but I'm talking about kind of big buildings in a student hall style that are operated by a private company where your agreement is with that private company, it's not with your university. And that leads us on to university halls. So these are more of like the classic halls arrangement. So where you rent something from your university, Their name is usually on the agreement. Often it's allocated to you in your first year of university. And then lastly, kind of other situations, so living landlords, property guardianships, like living on a boat, all those kind of things that kind of fall into a bit more of a general other category. So to start with, kind of the big one really that's going to have most of the changes we're going to be talking about. We're talking about privately rented houses and flats. So this is where a lot of students are living, usually second year onwards, sometimes before that. So before today, these would usually be assured short hold tenancies. They'd be for a fixed term. So you'd sign up for like a year, sometimes 2 or 3 years. And then when that fixed term ends, you'd kind of go on to what we call a rolling monthly contract, where it's just kind of month by month, you're paying your rent. You could give notice and leave if you wanted to. Generally, tenants in these ASTs, as we call them or called them, couldn't give notice and leave during that fixed term, and could be evicted via Section 21 with 2 months' notice. And often landlords would also, particularly with international students, ask students to pay 6 or 12 months rent up front. The difference today is going to be that all of those assured short hold tenancies will convert today automatically to assured periodic tenancies. So those new tenancies are very different. They don't have that initial fixed term for tenants anymore. So a tenant could give 2 months notice and leave at any time. But crucially, that kind of lack of fixed term doesn't apply to the landlord anymore. So the landlord can't use a Section 21 to evict you. They can't just, for no reason, decide that they want you to move out generally, although there are going to be some exceptions to that for students that I'm going to talk about. And yeah, they need to use a specific reason, and you're usually protected for the first 12 months from those reasons, providing it's like a no fault eviction. You haven't done anything wrong. And yeah, tenants can't be asked to pay more than 1 month's rent in advance. So I'm going to talk a little bit more about this in a sec, but we think that might kind of create potentially some issues for international students when it comes to renting this type of property, just because a lot of landlords do rely on that advance rent to kind of avoid a lack of guarantor. So what evictions now with these new assured periodic tenancies can landlords use? So I'm not going to go over all of them because it will take too long for this short session, but I guess ones that are kind of most relevant. So there's some new grounds where if the landlord's moving back into the property, or if they want to sell the property, they can do a kind of no fault eviction in that sense, in that you haven't done anything wrong, but they just want you to move out for those reasons. But they have to give you 4 months notice, and they can't do that in the first 12 months of your tenancy. And then there's the kind of like ones where you might not have paid your rent or not treated the property very well, in which case you'd have generally a shorter notice period. Also things like a lack of right to rent, they can evict you for. And then the big one that's going to affect students is ground 4A. So I'm going to talk about that. So yeah, ground 4A is basically a eviction category that exists exclusively for students. It doesn't apply to every single student. So there's some kind of criteria that the situation has to meet for the landlord to be able to use it. So firstly, you have to be a group of students. You can't just be like a student who has, I don't know, like a family and children living with you. They won't be able to use it in that kind of circumstance. It generally has to be in a HMO type property, so 3 or more people living in the property together. Generally, the situation needs to be that you were all students, or you were all supposed to be full-time students during the tenancy. So perhaps someone might have dropped out, but that won't necessarily mean the landlord can't use this. They'll only be able to issue this notice to expire between June and September. So there won't be a danger, hopefully, of the landlord doing this in kind of the middle of your exams or anything like that. And yeah, they have to basically give written notice that they're going to use this ground at the beginning of the tenancy. If it's like a mix of students and non-students, I think generally it is going to not be possible for landlords to use this. It is really for like student-let properties. And yes, they have to give you 4 months notice, and it can't be used in the first 6 months of the tenancy. It's going to be a little bit more complicated for existing tenancies. So assuming your landlord hasn't already given you a Section 21 notice sort of before today, then they may wish to give you a ground 4A notice to kind of evict you from the property at the end of what would have, I suppose, been your existing tenancy. As I said before, all assured short-hold tenancies are switching over to assured periodic tenancies. So you will now have an assured periodic tenancy if you previously had an AST and you haven't received a Section 21 notice. So in that case, if the landlord does want to use this ground 4A to evict you as a student, they will need to give you a written statement to say that kind of before the 31st of May. So not long to go for that. And it won't matter if it's still the first 6 months of your tenancy. For existing tenancies, they've kind of removed that just for now. It won't apply to any new ones signed after today. And it's only going to be 2 months' notice. So yeah, it's just worth bearing that in mind that that could happen. You could be evicted with a shorter notice period than 4 months. So yeah, things to note just generally about these assured periodic tenancies. So sounds great that you can give 2 months notice to leave at any time potentially during your tenancy. And I think a lot of students are going to want to take up that particular kind of opportunity. But it does apply to everyone in the property, presuming you're on a agreement where it's like a group of you and all your names are on one contract. Your 2 months notice will end that tenancy for everybody. It's not just for you as an individual. So if, say, one of you wants to go and the rest of you want to stay, we would still strongly recommend that you do kind of the usual thing that people probably already do in that circumstance, which is try and find a replacement tenant to take over your room and you're part of the contract. Because if you give notice, then you will be ensuring that all of your housemates can no longer live there as well. The ban on advance rent, as I said, I think we expect could have an impact on international students and people without guarantors' ability to rent properties, so or these type of properties, because a lot of landlords have that expectation that they'll be able to get advance rent in lieu of a guarantor, and that is no longer something they're allowed to ask for. So if that is something that might apply to you, then you may be able to take advantage of a guarantor scheme. Some universities run them, and also there's private ones available, but they are quite expensive. Landlords have to give you an information sheet by the 31st of May that explains the new rules. So you should receive this at some point if you're already in a tenancy. And just generally watch out for landlords for new tenancies trying to give you something other than an assured periodic tenancy. So it's kind of hard to talk about this in any detail in the kind of limited time we have. But the general rule that I would say is that if you are renting a house, flat, or room and you don't live with your landlord, in a kind of in a house or flat, so not in like a hall or anything like that, then you should have an assured periodic tenancy. If the landlord's trying to give you something that says license or holiday let or something like that on it, then it's a good chance that it's what we would call a sham license, where basically they're trying to give you less legal rights, so that they can potentially, in their view, evict you more easily. So yes, we'd always suggest that you make sure that your agreement does say assured periodic tenancy on it. If you're not quite sure, try and get some advice from somewhere. So private halls or PBSAs. So these at the moment, well, before today, sorry, would have either been sometimes licenses, sometimes assured short hold tenancies. Generally, always a fixed term, so you'd pay sign up for like 44 or 51 weeks. You wouldn't be able to give notice. They very rarely have break clauses, so you would have to have the room for the entire contract. And if you had an assured short hold tenancy, they'd be able to evict you using Section 21. And you'd normally be expected to pay your rent in large installments, so like per semester, 3 or 4 times a year. And it would be optional for those halls to be in an approved code of practice. So you may have heard of ANUK, who have a code of practice for halls. After the 1st of May, things are kind of changing, but not in the same way as other properties. So basically, you wouldn't be, if you sign a new agreement, you wouldn't get an assured periodic tenancy. You'd get something that's like a common law tenancy for private halls. And these would still be fixed agreements. You still wouldn't be able to give notice during the tenancy. You can still be evicted on a no-fault eviction at the end of the fixed term. And you can still be asked to pay rent upfront in large installments. In order for a private hall to actually use these new common law tenancies, they will have to be a member of an approved code of practice, sorry. to be exempt from the Renters' Rights Act rules. So basically, if they're not a member of one of these code of practices, they'd have to give you an assured periodic tenancy. We do know of like some providers of private halls who have been expelled from the code of practices. So there's a chance that in that case, if they're not able to reapply to get back into one, they wouldn't be able to use these common law tenancies. So it is worth checking if any hall that you're going to rent from is a member of one. Potentially, these kind of accommodations will be easier for international students to get into because they won't have the problem of potentially needing a guarantor because they'll be able to pay rent in larger installments. So that is a way around, I suppose, that problem, but it does limit you somewhat to these private hall providers. If you're in an existing PBSA assured short hold tenancy, then that tenancy will automatically convert to an assured periodic tenancy. This isn't standard. As I said, new contracts will be these common law tenancies. It's kind of a transitional quirk just for this year, basically. So if you've got a assured short hold tenancy with a private hall this academic year, you will now have an assured periodic tenancy. We thought when we first heard about that, great news. That means that lots of students, if they don't want to rent those halls over the summer, they can potentially give notice and leave. But we're not quite sure if that is actually the case. And this is to do with the way that rent periods are defined. So when you give a notice to quit, it normally has to kind of match your rental payment periods. And in instances where that's like a whole semester, then that could potentially mean that you can't actually give notice till the end of that period. It does completely depend on your contract, so we suggest getting legal advice, but this is kind of the position that we've found many of our students to be in when we've kind of checked this out with our solicitors, that they actually can't give notice till the end of the fixed term. So that's just something to bear in mind. I can't really give individualized advice about that, but I can potentially talk a bit more about that in the Q&A. Yeah, so if you want to leave your PBSA tenancy early, definitely seek advice. Don't just go because you might still have to pay even if you're not there. So just quickly, university halls. So these basically are halls that are run by your university, or university's name is normally what's on the contract. For these, you'll have a license. You would have had a license yesterday. You'll still have a license today on the 1st of May after the Renters' Rights Act's come in. Basically, there's no change to those whatsoever. Everything's the same. They can still ask for upfront rent. They can still evict you for no reason, basically. There's no difference. Same again, also, if you're living in like a house or flat that's rented from your university. So potentially if your university owns some like a accommodation like that, they can still issue you with a common law tenancy. So you wouldn't get an assured periodic tenancy from that. Other types of accommodation. So if you live with your landlord, you'll have a license agreement generally. And this again is kind of excluded from the Renters' Rights Act. So they can still give you like a license agreement. It can still be fixed term. They can still not let you kind of leave early if they don't want to, etc. So I would say probably before the Renters' Rights Act, I'd find that a lot of lodger arrangements were a bit more flexible, but in some ways, I think that lodger arrangements might sort of become a bit less flexible as a result of this, because yeah, it'd be easier for a living landlord to kind of enforce a contract potentially against you if they haven't given you an ability to end it early. Same again for anything else that's got a legitimate license at the moment. So things like, I don't know, if you're renting on a boat, or if you are in a property guardianship, which some may disagree with, but generally are considered to be legitimate licenses, then potentially you wouldn't have any new protections on the Renters' Rights Act. And just really quickly, I just wanted to touch on sham licenses. As I said briefly earlier, we do expect that there's a chance that a lot of landlords are going to try and get out of issuing assured periodic tenancies for houses, flats, and rooms in houses and flats. And how they do this is they issue what we would call a sham license. This is already an issue at the moment, or was previously sort of before the Renters' Rights Act, where landlords would sometimes try and give students things that say like holiday let agreement or license agreement, even though it's like it meets all the conditions of a tenancy. So it should be a tenancy, and it legally kind of is a tenancy, even if it says it isn't on the agreement. So just watch out for these if you're looking to rent a property and you kind of get something like this from your landlord. Definitely seek some advice about it. We give lots of advice about that kind of thing. And we also suspect that there might be a chance that landlords will start to do things to issue more legitimate licenses, so providing like meals and cleaning services to rooms, which would make something a license rather than a tenancy. Can't really get too much into that right now because it's quite complicated, but just something to watch out for. And if you want more info on this kind of specifically related to students, we have a housing guide on our website, housing.london.ac.uk, got a whole page on the Renters' Rights Act, and the whole guide is sort of been changed to kind of reflect the new changes. So hopefully that'll be helpful. And just to show our website there, housing.london.ac.uk, a few other places to get advice as a student if you have any issues. Hopefully I've not talked for too long. Thanks very much.
Brilliant. Thanks very much, Nick. And yeah, definitely not too long. And we appreciate all the detail that you put in there. That's really helpful. Um, I think yeah, we've got a few questions that are already coming in, but we'll save those until after we've heard from Amira, who who has the NUS's perspective. So Amira, when you're ready, please.
Absolutely. And thank you for having me. But really great to hear from Nicholas on all of the actual like details of the implementation. I think it makes sense for me to sort of track it back a bit because obviously the Renters' Rights Act has been on NUS UK's and student unions' radar for quite some time and quite a few years. I remember a few years back when Chloe Field was Vice President of Higher Education, the team were first discussing the bill and the opportunities for improving students' rental rights. When I was an officer at Birmingham, I also remember Nathan Wyatt and him sharing his story at the APPG for students. And so the sort of ongoing work and activism that student union leaders in NUS has played in this role in this particular piece of legislation is obviously massive. And it's really bizarre to be here on the day that it's like become real. But I think it's also, we've got an opportunity to celebrate certain things and also critique and get into the details of some of the challenges with some of it. The groundwork for this work was already in action before I was NUS president. Firstly, with the general election manifesto for our future, which included quite a few things about rental rights and the challenges that students were having as tenants. But I think the thing that we spent the most time on and which was then developed into the big campaign was around no more guarantors. And so to sort of contextualize, we had NUS research that showed that 29% of international students had experienced homelessness, which was more than twice the rate of our home students studying here in the UK. And then specifically estranged care experience and working class students were the ones that were disproportionately harmed and affected by these issues. And one of the things that sort of tied that thread together for a lot of those students was that the cause of this issue was primarily around guarantor requirements. Whether that was requiring a UK-based guarantor and you're an international student that just didn't know people in this country before you came here, or whether for our sort of estranged care experience and working class students, it was around being able to provide a family member that they had a relationship with or someone who was of a wealthy enough income, so either owned a home or received a certain income. And so what we found was that when people consistently failed to provide this, they were often asked to pay 6 months or 12 months rent up front at the beginning of the contract, simply because of, well, where they were born or how wealthy their family were. And so we had this sort of big issue. Now, for a lot of students, the number one thing that we needed to do was get rid of the entire guarantor system. And that's the line that we stood on. I remember October 2024, bringing together student officers. We met with approximately 74 members of parliament. It was a really widespread issue with a clear goal, which was to abolish guarantors. Student leaders handed them our briefings, et cetera. Westminster sort of became a buzz with this topic for the day. But follow through was clear, was key. And we then worked with the co-chairs of the all-party parliamentary group for students who helped us sort of land a partial win. And I think it's really important that we talk about this win because it is a partial win in that it is a development to deal with some of the symptoms, but there are challenges that come with it. It was clear that central government weren't supportive of a blanket ban on guarantors, which is what we were really trying to push for. And so we were also able to work on 2 other amendments that sort of aligned with that. One, which does really brilliant work actually to deter landlords from pushing and encouraging students to sign onto contracts really early. This was something that we saw a lot of students struggling with. So specifically, within their first year of uni, but in October, November time, already signing onto contracts that were, not due to begin till July before they'd had proper experience looking at properties, et cetera, et cetera. And so we were able to get a massive win there. But then also the other one was around banning rent up front, which was tackling one of the negative consequences and symptoms of the guarantor system. What's challenging is that rent up front option pushed lots of our sort of poorest students and our poorest international students out of the ability to be able to access properties. And yet at the same time, that system was also necessary for people to be able to access properties. So the Renters' Right Acts it will support students to be able to do tenancies. A lot of the changes will stop the rush to signing contracts before 6 months in advance, and it's going to ensure students are not made to put their rent up front, which is massive, and it's definitely something for us to celebrate. But as I said earlier, it doesn't come without flaws, and that's not just the lack of the adoption of the no more guarantors piece, which was the fundamental thing for us at NUS. It's also worth noting, so PBSAs in university halls are excluded, and some of those and some of the work around the actual transition into these new contracts, particularly for those on joint tenancies, is going to come with real challenges for individuals in specific situation. This transitionary period into this new system is going to have some negative consequences. However, all in all, this entire act, I think, speaks to a now propelled momentum to give renters the rights that they ought to have. And I think fundamentally to ensure students have, at the core of it, a warm and decent place to live. Our job now is also, I think, quite clear because there is still work ahead. We have to continue to work with organizations like Unipol, and I recognize Nicholas was actually speaking about some of those, the accreditation piece, like how do we ensure that, student protections are in place, that the quality of accommodation and in halls specifically is where it needs to be, and that work continues, and the role that NUS and student unions play in that remains to be key. We also need to ensure that our student unions are funded and supported to deliver the bespoke advice services to individual students at a time where we know that the requirement for advice is really likely to swell over this period. And we also need to ensure our universities and student unions and any sort of student adjacent organizations are doing the key know your rights work that we need to do at this moment in time in order for us to ensure that this legislation actually is able to have the positive impact that I think so many of us are excited and positive about. So I guess whether that is us setting up online housing hubs, whether it's the in-person briefings or the Know Your Rights campaign work, we're just in a really key moment where we need to make sure that students' understanding of this bill is where it needs to be in order for them to continue to fight and to protect their rental rights. Because fundamentally, the reason that students are vulnerable tenants is actually quite simple. Many of these students are first-time renters. They have no experience of renting before. Many of them are living on maintenance loans that come nowhere near what they need to cover their rent. And so their financial situation is often more precarious. And then also, many of them will only be in a property for a year, which makes them incredibly transient renters. And this often culminates in student renters being disproportionately exploited, and means that we need to continue to make proactive steps, and that those proactive steps have to be taken. So I guess I wanted to end by expressing that this act is a foundation. It's not the finish line. And fundamentally, students deserve nothing less than a housing system that's actually built for us, not against us. And that this act is something to be celebrated. It's a really, really promising step for renters of all shapes and sizes, including students. And we need to make sure to do the work that we need to do in order to keep students supported and effectively, supported through this system. But yeah, thank you.
Brilliant. Thanks very much, Mira. That was really, yeah, really good to get your perspective on that. And you're absolutely right about the extra vulnerability for students arising from just not being there for very long. Um, landlords, I think a lot of landlords go into the student market knowing that they can, they don't need to do very much between tenancies. I mean, I can remember when I was a student and, showing up to the house, and it was, yeah, it hadn't been cleaned or anything like that. It's Yeah, hopefully some of these measures and today's changes will help root that out. But yeah, it's definitely an area that still needs extra monitoring to to make sure it's working for students as well as everyone else. Great. Well, we've got a few questions that have been asked, um, which I'll have a look through and just see if we can get some input from you guys in answering these. Um, I guess one thing that has been asked is around the difference between joint tenancies and individual tenancies. So this person asks, is there any difference in rights between a joint tenancy with all four students' name on one agreement and a situation where each of the four students sharing a house has a separate tenancy agreement in their own name? Now, Nick, you did cover this, but it'd be good to, yeah, just
Yeah, I
if
mean,
you can reiterate.
there's no difference in your rights in that, you still have the rights of a assured periodic tenancy. I suppose the advantage of being on a separate, like individual room tenancy is that you can give notice, your 2 months notice and leave, and it doesn't affect anybody else. The other thing as well that tends to be the case when you have an individual room tenancy is that you have a license to use the communal areas, which means that effectively the landlord can enter your property without a notice in the same way that they would need to give on a joint tenancy because nobody has a tenancy of the whole property. So it does change your rights to communal spaces slightly and could mean if you're unlucky, you get a landlord that can turn up a lot. But otherwise, in some ways, there's a benefit to it because you're only legally kind of responsible for yourself. You're not responsible for anyone else's rent. There's no joint or several liabilities. So it doesn't matter if someone else in the house doesn't pay their rent. It's not your problem. You're only kind of liable for your rent for your room. So for students, I would say a lot of the time it's probably a more beneficial arrangement, but landlords very rarely do this, I would say, or more rarely do this compared to joint tenancies. And it's partly because I think legally they're liable for the council tax on the property in this kind of situation where they issue individual room tenancies. So they tend to try and avoid it and just, rent a joint tenancy to lots of students. But yeah, it does put students in a more precarious position if they want to leave or if their flatmate doesn't pay their rent to be on a joint tenancy. So yeah, hopefully that's enough.
Great, thanks. Yeah, that's really helpful. Um, there was a someone did ask about rent in advance, which you
Yes,
did
I,
you did
I
go
just want to
into.
touch on that. I saw that
Mm,
question. So what the person said was that landlords can't ask for rent in advance, but students or tenants can offer it. And that is true, but they're not allowed to accept that rent in advance until after the tenancy agreement is signed. So for me, I'm not sure how helpful that will be in terms of like a landlord being happy to rent to a student without a guarantor, because once you've got that tenancy agreement signed, then they've kind of got to give you the property, right? You've got a kind of right to
mm,
move in. So it's still sort of like it's hard for them, they'll still have to basically take a leap of faith in assuming that the student will actually pay the rent that they've agreed to pay. And that's what makes landlords reluctant. So yeah, it is helpful that a student could say, like, yeah, I promise I'm going to pay 6 months up front once it's signed, but whether that actually helps them secure the property or not, we don't know. And this is just things we're not going to know how the
mm.
market is going to respond until this has been implemented for longer than a day. So yeah, we'll have to
Yeah,
see what happens.
yeah, yeah, it's a really good point. There's a couple of questions about tenancies that have been signed prior to today. Um, let's see. What one of them did cover sort of the rent schedule. do you know if a tenancy that's been signed prior to today, the 1st of May, but commences in September, and includes a rent schedule that requires payment every 3 months, is that enforceable? Do you know?
Sorry, I'm just trying
Um,
to find the question. I find it easier to
sorry,
read.
yeah,
Hold on. If a tenancy has been signed prior to the 1st of May, commences in September, includes a rent schedule that requires. Um, do you know, I actually don't know. It gets really tricky
mm,
when it's not commenced yet. I know that
yeah,
if the existing assured short hold tenancy already has a like 6 monthly payment schedule, then that can continue unless you agree something else with your landlord post 1st of May. So students currently paying rent up front will continue to do so. I can continue to do so, but I'm not sure about these transitional ones where it's not started yet. It gets very complicated. So I can find out, but I won't be able to tell you now.
yeah,
I have
fair
to
enough.
ask our solicitors about that one.
Yeah, I think there'll be a lot of questions. I mean, there's another one here. It's quite a long question. I'm going to see if I can uh, distill it into one. Basically, yeah, it's about tenancies signed uh, to start in the autumn of the next academic year. Um, would these tenancies be classed uh, as ASTs or APTs?
Um,
Uh,
which one's that?
depending on
Sorry.
sorry, uh, in terms of purpose-built student accommodation.
Oh, okay.
So
Yeah, I think I can see that one. Is that Reed's question?
yes, yeah.
Yeah, I'll just pop that on Answer Live so people can read it. Yeah, so I read this one and I was interested in it. I don't know the answer, but it looks like the kind of thing that if what you're saying here is correct, that it's ambiguous basically between the tenancy kind of starting and being signed, then I suppose the only thing that would kind of really clear this up probably is if someone tried to give 2 months notice and left what they were arguing was an APT, um, and then maybe the private hall provider took them to court, and then I suppose a judge would decide
Mm,
whether it was an APT or not. I don't think it's going to be something that's likely to be clarified in any definitive way before then, but I'm not 100% sure. It's definitely a solicitor level question though, but I think it's something that
yeah,
even they would say maybe, maybe not, just from the basis of it.
great. Yeah, thanks. We'll see if we can if there are uh anything we can clear up on this, we will and send it around. In fact, we've got if anyone is not already getting our emails, my colleague will put a link in the chat in a moment so you can sign up and make sure you get any emails that we've got about the student situation, about student tenancies, particularly in this transition period. Um, I suppose there's a sort of follow up to the joint versus individual tenancies question about do you think landlords might do that more often, might offer individual agreements?
Um, I really just don't know what landlords are going to do. I think it's really up in the air, really. I think that in some ways it would probably mean that more people would use their 2 months notice if they are all in individual tenancies. So maybe that would be more chaotic for the landlords, but I just don't know.
Mm,
I think that I'm hoping, at least, just from someone who advises a lot of students, that students will have some mindfulness for their housemates. They won't just give notice and kind of, forget everyone else kind of thing. But obviously that is likely to happen at some point. But in that case, you'd think that the landlord would be more likely to want to keep the remaining tenants and just find some replacements rather than actually kind of kick them all out. But I just don't know. We'll just have to see how it goes really and how the market responds to it.
yeah. Thanks. just having a look at a couple of other questions that come in.
I can see one about ASTs
Yeah,
converting. I might just answer that quickly.
yeah,
So,
sure, please do.
um, yeah, so did I say that existing ASTs will convert to ATPs unless a valid Section 21 notice has been issued? Yeah, so from what I understand, if the Section 21 was issued before today, then that tenancy kind of stays as an assured short hold tenancy basically until the eviction is concluded. So it has to obviously be a valid notice, but yeah, that won't become an assured periodic tenancy because it's kind of the end of it has already started. When you say meaning 2 months notice can be given uh, when it converts to an ATP, there's when it's an assured
Mm,
when it's a short periodic tenancy, they can't give just 2 months notice to evict anymore, except in this transitional period with students where they can for the ground 4A eviction, but otherwise that's not a thing anymore.
yeah. With the sort of this year only the ability to use ground 4A
Mhm.
is um this is for any basically any HMO that's exclusively students or and
Yes. So
purpose built
it still has to
or
meet the conditions of a ground for a kind of eviction in other ways. So it has to be a HMO. And by when I say a HMO, I don't mean a licensed HMO of five or more people. I mean the kind of other definition of a HMO not related to licensing, which is a three or more unrelated individuals sharing a property. So if it's a one bed or two bed and there's only one or two people, or there's a family which isn't unrelated people living together, then in that instance they can't use ground 4A. And the differences between the transitional period are they only need to give 2 months notice for ground 4A for existing tenancies. Still has to end between June and September. And I was going to say something else, but I forgot what it was. Yeah, I think that's basically it anyway. 2 months notice. Oh, and it can still happen even if you've only just started the tenancy, even if it's the first 6 months.
yeah. Do you anticipate um any difficulties in the next few months with tenants uh giving notice when where they can and potentially homes not becoming available to next year's tenants. So someone's asked about um, the potential for landlords to double dip on rent. I guess when tenants move out and
Yeah.
tenants move in
Um,
before.
I'm not really. Do you mean as in if they move out before their tenancy has ended? Because I mean, landlords could do that already. Um, if they're, we've seen that before.
Yeah, I think if you've paid the rent already, but then you move out or
hmm.
before.
Well, they should. Yeah, I mean, if the tenancy's been lawfully ended, potentially they should. Well, it's an argument as to whether they should. I
Mhm.
think they should refund now after the 1st of May. They should refund overpaid rent, but I think previously it was a bit ambiguous. But yeah, I mean, potentially, but landlords have always done that even before. If students, weren't there for the summer, we've known of that happening, then moving people in when the other tenancy was officially still in place. But yeah.
Yeah, thanks. Amira, I'm conscious that Nick's been fielding a lot of these questions. Is there anything you'd like to come back in on? Um,
Yeah, no, I actually think a lot of those questions are obviously quite technical, and Nick, you did a fantastic job of answering them. I mean, just to touch on the rent up front one, it is just very difficult with the way that the system's designed because yeah, once you're already in the contract, that's when you can offer the rent up front. And obviously none of those rules apply for PBSAs. So for people living in those, then it doesn't really translate through. Looking at the um, questions, I guess the only thing I would say is like the likelihood that landlords are going to offer individual agreements rather than joint tenancies, I'm not sure that's actually going to change that much significantly with the changes. I think a lot of landlords will still reap the benefits from joint tenancy agreements and will lean that way. Um, yeah, I don't know. There's a lot of questions here.
um, yeah, I think we've answered most of these. There was one question just about the sign up link. I've just popped that in the chat for so hopefully everyone can see that. Um, there's a good question here that's just come in. Purpose-built student accommodation is the Unipol / ANUK code. The code they need to be members of to benefit to be exempt from the main tenancy reform of the Act. Are there no other codes they can join instead? Um, I've got a I've got a follow-up to that, which is maybe it's related to something that hasn't come in yet under the Act, but the property ombudsman, sorry, the private landlord ombudsman, which is going to be a body that can adjudicate disputes between complaints that tenants have against landlords. Um, do we know do we know any more about which student landlords are likely to be part of that, or if being part of the code could override the need to be part of that ombudsman?
I don't know.
Yeah, fair enough.
Hopefully they'll have to be a member of more than one, but I just don't know. I know
Yeah,
obviously for the private halls, I think the ones we know about are the ones they have to join. Um, and those kind of make clear what the expectations are of them. I don't think there's any new ones that I'm aware of, but
Yeah, I mean it's Unipol and UK. I think UUK and Guild HE also obviously do their ones specifically, but those are more for university-owned establishments. Um, and in terms of yeah, those codes, what is quite interesting is you can always sign up to be part of the student advisory panel for Unipol. And that's a space where people can actually have impact and influence over the codes, what they look like, and what's happening in that sense. It's not a perfect science, but it is a good opportunity for those who are interested to be able to get involved in the way that PPSAs are governed. Yeah.
thanks. I'm just checking if there's anything we haven't really got yet, but
I just saw
uh,
one that I just
yeah,
wanted to answer, which is that if
thanks, Nate.
student wants to give notice to quit, does the end date have to fall between June and September in the same way as a landlord giving notice does? And the answer is no. The student has the same rights to give their notice to quit in an assured periodic tenancy as any other tenant. So if they want to start the tenancy in September and give notice and leave in November or whatever, I guess they could if they wanted to. But yeah, I think that's the thing that's most stressing landlords out is that they think that a lot of their tenancies are all going to end, early, and whether that's going to mean that they're going to try and up the rent or something, I just don't know. We'll have to see.
Thanks. There's one here. I'm not sure if we've covered this yet. Does a tenancy have to have started before a tenant can give notice under the new act? Like say they sign in May, but then tenancy is not due to start until the 1st of July.
Well, it
Do
would have to
they
be, they could give, I guess they could give notice right away, but it would have to be a minimum of 2 months from
2 months? Yeah.
the start date of the tenancy. They wouldn't just be able to not start it by giving notice now, I guess, if they've decided they don't want to rent it anymore.
Yeah. Um, okay. I think we've covered all of these, all the rest of the questions. So thanks. One of them's just come in actually. I'll give it a quick read. Uh, no, I think that's the one we've just covered. Okay, I think we can draw it to a close then. Thanks everyone for asking questions. I hope we covered those. We will be trying to get some clarification over the next few weeks about some of these questions that are still a little bit unclear. And it's only come in today, the new law, and it's likely that we'll find out a few more things that we might not have been able to anticipate. But we'll certainly do our best to make sure that everyone knows what to look out for as students or people advising students. And that's what one thing I've popped in the chat. We'll put it on YouTube as well. Is a link to sign up for any further emails on that. But thanks very much to Amira Campbell and Nick Coomber for taking us through all the changes that are happening today. Really appreciate all your insight and wisdom. And yeah, let's hope that it's as smooth as it possibly can be over the next few months. And whether you're whether you're moving out in the next few months or moving into a new place, all the best for that. And do let us know how you get on, and do sign up for our emails about renting as a student. Thanks very much, and enjoy the bank holiday weekend.
Thanks, Dan.
Thank you,
Bye.
everyone.